This video is sponsored by Webull. Webull is currently having a promotion where you can get up to $100 worth of Google shares and an FWD Insurance 50% coupon. All you need to do is make a first deposit of 1,965 Singapore dollars and make 6 trades of US stock, ETF, or options, and hold your deposit for 30 days. It's that simple. It is an immediate 7% return on investments. If you are looking for financial freedom, it is surely an offer that you should not miss. The terms and conditions and the links to get this limited time offer are in the description below. Now let's get back to the video. 1. We wish to inform you that, at the hearing of the Judicial Management Applications, JM Applications, on August 1, 2022 before the Honorable Justice Vinod Kumaraswamy, the court granted judicial management orders against the companies and appointed the IJMs as judicial managers, JMs, for the purpose of putting the companies into liquidation, court's proposal. A summary of the proceedings is set out below. 2. Drew and Napier, D&N, acting for Samgo, informed the court that the companies had not appointed counsel. D&N submitted that Samgo was in favor of a private restructuring, for example by way of a scheme of arrangement, and asked the court to dismiss the JM applications. However, if the court were to grant judicial management orders against the companies for the purpose of placing these companies into liquidation, Samgo proposed 3 alternative nominees to be considered for appointment as JMs in place of the current IJMs. In this respect, D&N informed the court that they had filed a letter on August 1, 2022, prior to the hearing, enclosing fee quotes from their alternative nominees for JMs, liquidators and suggested giving parties more time to consider the quotes provided. 3. The court noted that if it were to dismiss the JM applications, there would no longer be a moratorium protecting the companies against legal actions, including winding up applications, and queried how Samgo intended to protect the companies. The court further remarked that a scheme of arrangement is a debtor-in-possession mode of restructuring where the company has a viable business model, and asked what aspects of the company's business can be restructured. The court noted that the company's business is largely defunct. Assets have been frozen by the Commercial Affairs Department and there are ongoing investigations, and queried what Samgo can do in a private restructuring that cannot be done in a liquidation. 4. With respect to how Samgo intended to protect the companies if there is no longer a moratorium, D&N submitted that this will need to be worked out. With respect to what aspects of the company's business can be restructured, D&N submitted that there are still viable aspects of the business that can be restructured. However, D&N was unable to provide specific details on this. D&N stated that creditors would not be worse off if the JM applications were dismissed, and that if Samgo is allowed to explore a scheme of arrangement with the creditors there is at least a hope of rescue. D&N informed the court that Samgo has been approached by potential white knights and that there were discussions but no details were provided. 5. The court noted that the IJMs were appointed 6 months ago and that there was nothing stopping Samgo from engaging the IJM sooner to try and achieve the restructuring he now wishes. D&N explained that Samgo had thought that the IJMs would work with him, and that the creditors' views on his proposal for a private restructuring could be ascertained by the IJMs at the creditors' town hall on May 31, 2022. On this, the court remarked that it was for Samgo to work with the IJMs and not for the IJMs to work with him. 6. Rajan Tan, R&T, acting for the IJMs, submitted that though only a small proportion of the company's creditors have responded on the court's proposal to place the companies under judicial management for the purpose of placing them into liquidation, an overwhelming majority of those who responded, 460 creditors with a total debt of about $20.2 million, support the court's proposal, with only 19 creditors, with a total debt of about $2.6 million, against the court's proposal, i.e. in favor of Samgo's plan of a private restructuring. R&T further submitted that, of the creditors who were supportive of the court's proposal, 67 creditors, with a total debt of about $2.6 million, were in favor of appointing the IJMs as JMs, liquidators while 6, with a total debt of about $300K, were in favor of appointing one of Samgo's nominees as JMs, liquidators. 7. R&T submitted that the I.J.M.'s assessment of the prospects of achieving the objects of judicial management have been set out in the first report and supplemental report, and it was the I.J.M.'s recommendation that the companies be placed into liquidation. R&T further submitted that the court has the discretion under Section 9110 of the Insolvency, Restructuring and Dissolution Act 2018, IRDA, to place the companies under judicial management on the basis of public interest. 8. After hearing parties, the court stated that it was not inclined to dismiss the JM applications as it did not consider it would be appropriate to allow the companies to continue under the control of their director, which is what would happen if the JM applications are dismissed. It would be more appropriate for the IJMs to continue in office, as JMs, until the companies are placed in liquidation. To the extent that there are prerequisites to making the judicial management orders, for example advertisement of the JM applications, the court exercised its discretion to dispense with them. Further, the court expressly stated that its decision for making the judicial management orders is on the basis of public interest, in exercise of its discretion under Section 9110 IRDA, having considered the size of the businesses, the number of creditors and the diversity of their geography, the amount of debt, the fact that there are criminal investigations, and the fact that there is cryptocurrency involved. The court was satisfied that the judicial management orders can be made notwithstanding that the statutory purposes of judicial management cannot be achieved, and considered this course of action, rather than dismissing the JM applications, to be for the benefit of all creditors. 9. On the issue of who should be the candidate, the court noted that the only issue before it at the hearing of the JM applications is who should be appointed as JMs if the court were to grant the judicial management orders for the purpose of placing the companies into liquidation. The question of who should be appointed as liquidators will be decided by the judge who hears the winding up applications. In this regard, the court noted that the fee quotes for the judicial management period provided by the various SAMGO nominated candidates were not so disparate from the I.J.M.'s estimate for the same period. 10. At the conclusion of the hearing, the court granted the judicial management orders and ordered that the IJMs be appointed as JMs. The court further ordered, amongst others, that the JMs are to apply as soon as reasonably practicable to place the companies into liquidation, and that the companies, the JMs and any creditor or person claiming to be a creditor shall have liberty to apply. 11. The JMs wish to thank all creditors, especially the creditors who provided their views and feedback to the IJMs and or attended the hearing for their participation, and will continue to keep stakeholders informed of any material developments. 12. This email notification is being issued to creditors of the companies and all other parties who have indicated that they are interested parties and or assert claims against the companies. Please note that your receipt of this email should not be construed as an admission or acknowledgement of the validity of claims asserted against the companies. End of the email.